Good. In Italy, it's not always good to begin on time, but it's always good to end on time. I take that to be a rule of thumb. So, no introduction, no conclusion. I'll just, in the fashion of certain analytic philosophers, begin. The title is Personhood of Society and Subsidiarity. Margaret Thatcher famously said that there is no such thing as society. There are only individual men, women, and there are families. Lady Thatcher was surely correct that groups like families, polities, clubs, teams, and so forth do not possess the unity of an individual substance. The two creation myths in Genesis, for example, clearly distinguish the one-flesh unity of Adam and Eve from the sequence of natural kinds. In this, Scripture seems to confirm common sense and untutored observation. Marriage does not have a nature in the same sense as a plant, a bird, or even a human being. When two or more people are constituted in a society, there is not produced a second or a third natural kind. In answer to the question, then, what kind of a thing is a society? The right answer seems to be that a society is a person. We recall Thomas's famous definition of a person as that which is distinct by reason of dignity. Quote, "For as famous men were represented in comedies and tragedies, the name person was given to those who held high dignity. And because subsistence in a rational nature is of high dignity, therefore every individual of the rational nature is called a person. Now the dignity of the divine nature excels every other dignity, and thus the name person preeminently belongs to God." Here Thomas is referring to the Latin word persona, the mask used by actors to impersonate a well-known character, someone distinct in dignity. And in a Roman family, if you had reached the rank of praetor, you had the jus imaginum, that is, the right to publicly impersonate. Roman jurists transferred the right of impersonation, and make no doubt, impersonation begins before personation. Okay. This is well proved by anthropologists today. But the jurists transferred the right of impersonation to the legal status of a person, and only later did theologians and philosophers transfer the idea of impersonation to a rational individual substance, to the very thing personated, to persons both human and divine. In the tradition common to jurists, philosophers, and theologians, there were at least three kinds of persons. First, there are natural persons, and here the word natural is used to denote whoever possesses the unity of rational substance. Human persons, angelic persons, or divine persons sharing the unity of a single substance, and in the case of Christ, two natures in one person. Second, there are what the law calls fictional persons. As Thomas Hobbes noted, there are few things that are incapable of being represented by a fiction. Inanimate things like bridges, hospitals, and houses can receive endowments and thus bear interests in rights at law. Like Caligula's horse made a senator by imperial decree, such entities are distinct in dignity not on account of their own nature, virtue, or power, but rather by a fictio legis, a construction of the law. Third, there are what should be called real persons, persons having neither the unity of a substance nor a unity merely imposed upon things in the fashion of fictional persons. And such persons, real but neither substantial nor fictional, are called societies. A society possesses what Thomas Aquinas called unity of order. Quote, "It must be known that the whole which the political group or the family constitutes has only unity of order, for it is not something absolutely one. A part of this whole, therefore, can have an operation that is not the operation of the whole. Therefore, as a soldier in an army has an activity that does not belong to the whole army, but the whole does have an operation that is not proper to its parts, but only to the whole." Unquote. So, things enjoying unity of order each possess what is individually proper to themselves, certain operations and acts that are not reducible to the commonality, not canceled out by membership in a group. At the same time, a society enjoys a real unity transcending mere aggregation of its members. So, wherever there are plural rational agents aiming at common ends through united action, and where the unity is one of the goods being aimed at, we have a society, something distinct in dignity. It will hold itself out to the rest of the world as something distinct in dignity, possessing rights and responsibilities. By the way, I'm just cribbing this ontology from Aristotle and from Pius XII's Mystici Corporis, but anyway. Thus, the scriptural hexameron crowns the 6 days of creation, not with another natural kind or substance, but rather with a society. In Jewish and Christian allegorical exegesis, this society was in turn the type of another society, Israel or the church. Indeed, as Augustine argued in the last 3 books of the Confessions, creation is for the sake of the church. In his seminal essay on moral personality and legal personality, the famous British legal historian F.W. Maitland writes, "When a body of 20 or 2,000 or 200,000 men bind themselves together to act in a particular way for some common purpose, they create a body which by no fiction of law, but by the very nature of the things, differs from the individuals of whom it is constituted. If the law allows men to form permanently organized groups, those groups will be, for common opinion, right and duty-bearing units. And if the lawgiver will not openly treat them as such, he will misrepresent, or as the French say, he will denature the facts. For the morality of common sense, the group is a person, a right and duty-bearing unity." Unquote. So for Maitland, when individuals, with a note of permanence, engage in united action for a common purpose, there comes into existence a unity that transcends its parts. There comes into existence a group person, a society, that requires the rest of us to recognize not only the individuals, but what Maitland called N+1 persons. It would denature the facts, he says, to pretend otherwise. Now, every society will depend upon individual persons. This is just what Aristotle and Thomas meant by a unity of order, inasmuch as the members are not reducible to the whole as accidents to an underlying substance. Groups are not ontologically basic in the order of substances, but they are basic in constituting a unity that excels the parts and in the order of finality. As the scripture says, after creating individual substance, God said, of the whole, it's very good, not just good, but very good. The group or society, and not just the individual members, should morally count as an agent and as a patient. As the bearer of rights and responsibilities, a society can harm and be harmed in the moral sense of the term. We morally harm a society when we refuse to recognize its common good and its agency as an N+1 person. This is what John Paul II meant by the subjectivity of society, that thing canceled out by real socialism. He simply meant that a society is something more than intersubjectivity. In the case of a society, the intersubjectivity constitutes a subject in its own right. A number of individuals in a shopping mall certainly evince intersubjectivity, but without pretending to constitute a society. Regarding this species of intersubjectivity, Hobbes refers to a mere concourse of people, without union to any particular design by obligation of one to the other, but proceeding only from a similitude of wills and inclinations, unquote. This kind of concourse of individual wills or desires, more or less spontaneously converging upon similar objects, is what we might find in the marketplace of a city. It is not harmed, and quite likely is facilitated when we refuse to give it the status of a society or a group. Societies are to be distinguished not only from what Hobbes calls a concourse of wills, but also from a more specific agreement of wills typical of a partnership. In a partnership, 2 or more people deliberately and explicitly make a contract with respect to mutually agreeable ends. Now, admittedly, the distinction between a partnership and a society is tricky when we examine ordinary concrete facts. For one thing, partnerships can become societies, and societies can devolve into mere partnerships, a fact that's proved every day in suburban America. But both can be brought into existence through the instrument of a contract. But as regards the law, a brief example might suffice. Putting marriage and the state to one side, American law usually refrains from tracking exactly every ontological difference between group persons. For example, if one files for a not-for-profit corporation in the state of Oklahoma, the law instructs as follows, quote, "The name of the corporation must contain one of the following words or abbreviations: association, company, corporation, club, foundation, fund, incorporated, institute, society, union, syndicate, limited, company, incorporated, limited, or words or abbreviations of like import in other languages, provided that such abbreviations are written in Roman characters or letters," unquote. The filer is likewise instructed that the address of a church must be a street address and cannot be a post office box address. This is really aimed at the Oklahoma situation, I think. But the law is interested that the church exists as something more than a mere transient medium. Interestingly, the instruction also goes on to say, quote, "All domestic corporations shall have a perpetual duration unless otherwise stated," unquote. This is just Aristotle going through Oklahoma statute law. Unlike the life of a natural individual, and unlike the routine contract for exchanging goods and services, both of which are assumed at law to be mortal, with a definite beginning and an end, a society implies perpetuity. Societies are immortal, just as Cicero and Aristotle and Augustine said. They are assumed to be perpetual precisely because they do not depend upon the unity of a natural substance, nor is their unity exhausted in a single exchange. Now, the point of this digression is that in a relatively free polity, the state is prepared to accept within broad parameters of common sense the existence of societies other than themselves, and to accept them more or less on the terms they hold themselves out to be, provided, of course, that the group is not acting for criminal ends, that the group possesses an internal organization governed by its own rules, and provided that the group make proper accounting of its monies. The state is usually only interested in the money. This is why we find more ontological distinctions about society in the tax code than in the law of corporations itself. Now, let's return to the distinction between mere partnership and a society. In a mere partnership, the work is traceable to the individual partners, but not to the partnership itself. One who supplies Daimler Chrysler with auto parts does not intend to bring about a society. No corporate personality is aimed at. The reciprocity has no aspect of permanence. It has no united action. Indeed, it requires no society whatsoever, except incidentally, in breach of contract, in which case the partners repair to the courts of the political society. Mere partnership, as Yves Simon once observed, does nothing to put an end to the solitude of the partners. In our example, it's sufficient that one delivers the parts, that Daimler Chrysler assembles the cars, and that various individuals write monthly checks for leasing the equipment. And this is just as it should be, for it would be suffocating if every human exchange, ipso facto, constituted a society. It would cancel out the networks of contracts and alliances in which we make and disengage temporary partnerships. A society, for its part, does not just aim at a common objective, but intends to have it brought about by united action. Think, for example, of a family, a faculty, a crew team, or an orchestra. In each case, the reason for action includes the good of common action itself. Achievement of mutually agreeable results is not enough. For each of these groups, their respective corporate unity is one of the reasons for action. Thus, in the case of a society, unity is an intransitive good. Ordinarily, it survives the failure of the crew team to win the race, the failure of the marriage to produce children, the failure of a polity to negotiate a treaty with another state. Partnerships, however, usually do not survive failure of the partners to secure the mutually agreeable ends for which the arrangement was constructed. The best rule of thumb for distinguishing between society and partnership is not abstract. Just watch and see what happens. Societies typically survive a failure to achieve their ends. Partnerships do not. Now, the diverse set of non-governmental associations is usually called civil society. That there be a civil society distinct from the formal organs of the state, and that civil society be recognized at public law, are today completely uncontroversial propositions, just stated at that level of generality. Yet, since the 17th century, we have inherited quite different understandings of the nature of civil society, because we have quite different understandings of the ontology of group persons upon which it would seem to depend. I'll call one the devolution model, and I'll call the second the subsidiarity model. Beginning in the 17th century, one of the most urgent questions was how to reconcile the state's monopoly over public authority and power with the myriad of other groups claiming authority, rights, and liberties according to custom, natural law, and ecclesiastical law. How does state sovereignty, which recognizes the state as the preeminent, if not the exclusive group person, comport with what Maitland called right and duty-bearing unities that we have called societies? By the way, the whole loss of the Roman Republic was summed up when Caesar Augustus outlawed the right of using the ancestor masks. He absorbed them all to himself. The right to impersonate became the site of the sovereignty. Now, Thomas Hobbes provided an early and remarkably clear model for understanding the relationship between groups and the sovereign state. It's been called the Concession Theory. Simply, Hobbes writes, "For power unlimited is absolute sovereignty, and the sovereign in every commonwealth is the absolute representative of all of the subjects, and therefore no other can be the representative of any part of them, but so far forth as he shall give leave," unquote. For Hobbes, once the sovereign comes into existence, there can only be one legitimate group person. Other group persons may exist, but only by the permission or concession of the sovereign. The modern French state began exactly on this note. Article 3 of the French Declaration of the Rights of Man and Citizen, quote, "The principle of all sovereignty resides essentially in the nation. No body nor individual may exercise any authority which does not proceed directly from the nation," unquote. And 2 years later, the French state passed the law against corporations, the infamous Chapelier Law, which I quote in part. "Citizens of the same occupation or profession may not, when they are together, name either president, secretaries, or trustees, keep accounts, pass decrees of resolutions, or draft regulations regarding their alleged common interests," unquote. Soon, laws were enacted against religious orders, universities, and so forth. Now, we must ask, why should a sovereign ever grant a concession? We know why sovereigns don't want to grant concessions, because they don't want rivals in the order of group persons. But why should they grant a concession? And I think we should think of devolution. Imagine a homogeneous power formally belonging to the state. The state, however, decides to parcel out aspects of this power from the top down. It does not deny its own plenitude of power or sovereignty, but it recognizes the contingent fact that it cannot effectively or efficiently reach all of the objects within its formal power. Accordingly, the state will outsource power by way of quasi-delegation to other groups, like Halliburton, for the purpose of efficiently creating or distributing certain groups' goods and services. The complexity and scale of the modern state practically guarantee that the sovereign has to make concessions. It must learn to devolve, as even China is doing today. So let me give an example. Take, for example, the debates in Europe and the United States over the issue of marriage. What kind of group person is a marriage? In 1992, the Hawaiian Supreme Court defined marriage, quote, as a partnership to which both parties bring their financial resources as well as their individual energies and efforts. It could have said exercise machines, 401k accounts, and other things. The point was reiterated in the controversial 2003 decision of the Massachusetts Supreme Court, which prohibited the legislature from giving legal title of marriage only to one man and one woman. Let us put to one side the moral issue of whether marriage ought to be exclusively heterosexual. This puts the cart before the horse. First, we want to know whether there are group persons distinct from mere partnerships. And second, what reason the state has to recognize them. And here I quote from the Massachusetts Supreme Court decision. It gives a very crisp answer to the question. We begin by considering the nature of civil marriage itself. Simply put, the government creates civil marriage. Civil marriage is created and regulated through the police power of the Commonwealth of Massachusetts. Civil marriage anchors an ordered society by encouraging stable relationships over transient ones. It's central to the way the Commonwealth identifies individuals, provides for the orderly distribution of property, ensures that children and adults are cared for and supported whenever possible from private rather than public funds, and tracks important epidemiological and demographic data, unquote. So, here we read that the state does not merely regulate marriage, but creates it through the exercise of the police power. What aspects of good order move the state to allow married people to be a right and duty-bearing unity? The court mentions economic reasons, property, sociological reasons, stable relationships, health reasons, care for the old or indigent, scientific reasons, collection of epidemiological data. It's sort of that marriage, because it has an address and the state knows where to find you, is very rich soil for collecting epidemiological data. Now, the state breathes into the dust of sexual relationships and private aspirations for sexual intimacy and creates a person at law. This person then becomes the site or occasion for bringing about more efficiently certain results which are in the interest of the state. All that remained for the Massachusetts court to do was to judge that one gender or two genders are immaterial to the state's interests in having other agents procure the publicly desirable results, and therefore not to favor one arrangement over the other. The Massachusetts decision is a pure example of concession theory. Hobbes would be proud of them. With one footnote, though, Hobbes was in doubt whether how deeply the sovereign could constitute paternal authority within marriage. But that is a footnote. The court in Massachusetts leaves untouched the question whether this juridic person is a society or a partnership. The public efficiencies falling with her view of the positive law could be attached to either a partnership or a society. I skip over other examples of devolution theory. The subsidiarity model. The question of whether there exists social persons distinct in dignity, reducible neither to the individual nor to the state, stands at the very outset of Catholic social doctrine. Earlier, I said that our models of civil society have developed chiefly in response to this post-Westphalian situation of sovereign states. In Europe and her former colonies, the Catholic Church not only lost its political privilege in the new nation states, the Church, along with her religious orders, schools, seminaries, and sodalities, was stripped of juridic personality, except such as remained by the concession of states. A society of monks, for example, could not hold themselves out to the rest of society as monks, but rather as makers of pottery. There's the Massachusetts model, you see. Monks are not truly monkish. They don't have a monkish society. Rather, the state has to pretend that it has an interest in bringing about more pottery through the handicraft of these monks. The Article 27 of the 1917 Mexican Constitution was far more severe than the French example I just gave. Quote, "The law recognizes no juridical personality in the religious institutions known as churches." Catholic social doctrine accordingly emerged in defense of two propositions. First, that the state does not enjoy a monopoly over group personhood. Second, that societies other than the state not only possess real dignity as rights and duty-bearing unities, but that they also enjoy modes of authority proper to their own society. So, in rerum novarum, famously, Leo XIII defended the right of workers to form associations. Right? According to Leo, all societies spring from the same source, namely, the tendency of man to dwell in society. Society does not devolve from the state or come into existence because of the state's need to outsource powers for socially useful ends. But in rerum novarum, he raises another issue of co-equal importance. He writes, "In order that an association may be carried on with a unity of purpose and harmony of action, its administration and government should be firm and wise. All such societies, being free to exist, have the further right to adopt such rules and organizations as may best conduce to the attainment of their respective objects." Unquote. So, wherever there is a society, a group person marked by common ends and unity of action, there must be authority. Leo's point is that the state will do an injustice. It will harm a group person if it allows societies to exist but denies their capacity for self-government. Where there is no right to group authority, common action will depend entirely on spontaneous unanimity, and this is hardly possible in a family, much less in an economic corporation, a university faculty, a church, or even a sports team. Hence, a state that recognizes the existence of a society, but not the diverse modes of authority appropriate to a society, reduces civil society to mere partnerships. Whether it says it's done that or not, that's what it's just done. Partnerships don't need authority. On this score, we can distinguish then devolution from the older notion of subsidiarity. The term, of course, was coined by the 19th century Italian Jesuit Luigi Tapparelli. For Tapparelli, who was Leo's teacher when Leo was at the age of 10 years old. Leo became a student of Tapparelli at the age of 10 here in Rome. For Tapparelli, subsidiarity is not a freestanding concept. As a principle regulating and coordinating a plurality of group persons, subsidiarity presupposes a plurality of such persons, each having distinct common ends and kinds of united action and modes of authority. It is not, therefore, a question of whether there shall be group persons or whether they are efficient or immediately useful to the state. Rather, the question is how these groups stand to one another and to the state. In its negative formulation, subsidiarity demands that when assistance is given, it be done in such a way that the sociality proper to the group is not subverted. Hence, for Tapparelli, it describes the right, the rito imputatico, of social groups, each enjoying its own proper mode of action. Tapparelli also used the expression associazione imputatica to emphasize the interdependence of societies, each maintaining its own unity without prejudice to the whole. So on this view, subsidiarity cannot be construed as judgments, decisions, actions at the lowest level. The notion of a lowest level perverts the concept of subsidiarity. The better term is proper level. The lowest level can only mean the individual or perhaps partnerships which are aggregations of individuals. Subsidiarity, on the other hand, presupposes that there are plural authorities and agents having their proper, not necessarily lowest, duties and rights with regard to the common good. By the way, what's the lowest level of Petrine authority? See what I mean? What's the lowest level of paternal authority? And you find yourself asking a stupid question, right? You already know what the answer is because you are substituting in your mind proper rather than lowest. Once we distinguish subsidiarity from the similar but misleading notions of devolution, it's easier to grasp why it was introduced into Catholic circles as an aspect of social justice. For Pius XI, for example, social justice is that kind of order that ensues when each person is capacitated to exercise his social munus, that is, to contribute to the common good according to his proper office and mode. This may or may not require the giving of aid or the correction of a deficiency. Now, I can answer the question that I didn't ask at the beginning because it was in the introduction. Why did the older category, Doctrina Civilis, all jurists, philosophers, theologians, before Leo XIII spoke of Doctrina Civilis, that is, teachings on the order about the order of the state, why did this term disappear after Leo's pontificate in favor of the term Doctrina Socialis? And now we know the answer. Because the church was responding to a prolonged attack upon the sociality of societies, first by the industrial era nation states, and then during the pontificate of Pius XI by totalitarian regimes. What the church saw happening was the state becoming the only legitimate group person. And therefore it had to back up to not just give a doctrine about the state, but to engage the more fundamental ontology of what these unities of order are called societies. Finally, I conclude. In Centesimus Annus, John Paul II weaves together the various strands of this issue. Quote, "The primary responsibility in social justice belongs not to the state, but to the individuals and to the various groups and associations which make up society. In addition to the tasks of harmonizing and guiding development, in exceptional circumstances, the state can also exercise a substitute function. Such supplementary interventions must be as brief as possible, so as to avoid removing permanently from society and business systems the gifts of service which are properly theirs. Propria munera." Here again, I'm quoting, "Here again the principle of subsidiarity must be respected. A community of a higher order should not interfere in the life and community of a lower order, depriving it of the functions which properly belong to it." Again, the term is propria. Notice that he says higher and lower orders, that is, societies. This is why the principle of subsidiarity cannot be expressed adequately as the imperative that decisions be made at the lowest possible level. The lowest level is cost-benefit calculation or spontaneous unanimity in which no authority is needed. Neither of these presuppose a society. Subsidiarity is nothing other than the principle that the sociality of society be preserved. No argument to good results external to a society will suffice unless there's a moral reason to dissolve a society, a regime, or a party. That subsidiarity refers not to individuals but to a plurality of societies, was made clear by John XXIII in Mater Magistra. Quote, "The state's work is directing, stimulating, coordinating, and supplying and integrating a plurality of societies. Of its very nature, the true aim of all social activity should be to help members of the social body but never destroy or annul them." And he concludes, "These groups must be really autonomous and loyally collaborate in the pursuit of their own specific interests and those of the common good. For these groups must themselves necessarily present the form and substance of a true community, the matter and form of a society, of a unity of order." Catholic theory set out, therefore, neither to make state sovereignty more effective or less effective. Rather, it defends the intrinsic dignity of group persons, including the state, in their own right. The sin of the modern state is the injustice of claiming a monopoly over group personhood, reserving what is distinct in dignity for itself and for individual persons. The Catholic position holds that the political sovereign is limited by the very existence of real group persons other than itself, some higher, some lower. A normal society then will evince a multiplication of authorities embedded in plural group persons. On this view, subsidiarity is not devolution. It's a principle governing the harmony and coordination of group persons. There may indeed be good reasons for a state to devolve, but if my account is correct, devolution must respect the principle of subsidiarity. Devolution is a policy. Subsidiarity is the principle. Thank you.